For many centuries, lawyers seeking cases to support their arguments in court had to undertake many hours of painstaking study and research to find relevant precedent.
The traditional book form is still available. It's still published. A lot of people like books. They look beautiful on the shelves, particularly if they're going back to 1821, and they can be very easy to use if you're accustomed to that.
In the old days, the lawyer acted as his own search engine because he would go through the hard copy indices and work out which case or cases to follow up. Now his task is simplified, or her task is simplified, thanks to search engines.
The computer age has revolutionized legal research, and it's revolutionized the availability of legal materials.
Electronically, the reports are made available through various publishers. You can get them on Justice, you can get them on LexisNexis, you can get them on Westlaw. And anyone who has a subscription to any of these services has access to the electronic versions of session cases.
You just need to know the vague topic that the case is on, and you can find it through that medium. The benefit is speed. You don't lose a huge amount of time trying to search for physical copies. And also, before you would have had to go through all the physical copies of the case citators to figure out whether this case that you found in 1893 is still in force. Now, this electronic search tells you whether this case has been overruled or commented on in any subsequent case. So it's up-to-date information about the authority of that case.
Additionally, session cases, through all the main online legal databases, can provide PDF versions of the law reports.
Well, the PDF versions are particularly useful because they mirror the hard copy.
And so working from an electronic version of that means that you and the judge are literally looking at the same page.
Courts all over the world now, if they have an analogous case, are able to look at the session cases version electronically to see if the same issue has been considered by the Supreme Courts in Scotland and how they dealt with it.
It's important not just to look at your own precedent from your own jurisdiction in support of your argument, go beyond the boundaries of your jurisdiction, and you will probably find greater support for the argument that you're seeking to make.
We believe in Canada that Canadian judges don't have a monopoly on good thinking about legal problems. And so it seems natural to try to take advantage of good thinking that's been applied to similar problems wherever you can find it.
Now one has greater accessibility to Canadian decisions, to Australian decisions. They were there, but they are now more accessible. And so there is a greater use made of these decisions as material which may be helpful or persuasive in a particular direction.
So I think that in that sense, access to a wider range of material is bound to improve the quality of justice that is rendered in a particular decision.
The Scottish Council for Law Reporting and session cases are committed to being at the forefront of law reporting, and the whole idea is that whatever the needs of the lawyers, whatever the needs of the courts are, the Scottish Council for Law Reporting and session cases will be able to provide that in the future.
The law is about people. It's about people in a variety of different situations, some pleasant, some unpleasant, and as part and parcel of the keys to unlocking and perhaps improving their lives are the words that are recorded in these rather fine leather-bound books. Without them, we'd all be a lot poorer, I think.